Yeah. Six APA. Oh, no, it's a academy. But then.
So 6 days, I think it's done. This surgery that one.
So I guess the bar association sent it out, but it's probably not specifically affiliated with the bar, probably the family, these kids. And so they're the, you know, we took the hammer battles and all that good stuff, so he was always the character. Yeah.
Oh, yes, it's great.
Once she's well, now there I did have a lot of contact with them. One back to the university. But it was close to sending me my it was too much to lend a pass. Cheap copy, so.
You got this one? This one's this side.
There's a number.
All rise. The Honorable Justices of the Supreme Court. This court from recess now sitting.
Please be seated. Good morning, everyone. Thank you for your patience with us. We went a little long on our 9 o'clock docket. Would now ask Mr. Doug Shima, the clerk of the Kansas Appellate Court, to please read our 10:30 docket. It's really kind of an 11-ish docket.
The 10:30 docket for Wednesday, April 2nd, 2025 consists of 2 cases. First case, appeal number 125925, State of Kansas versus Adam Drew Humphrey, Saline County, briefs both sides.
Good morning, Your Honor. My name is Randall Hodgkinson. I'm appearing today on behalf of Adam Humphrey, and I'm ready for argument.
May it please the court, Assistant Solicitor General Ryan Ott, appearing on behalf of the state of Kansas, present and ready for argument.
Second case is appeal number 128447 in the matter of Thomas C. McDowell, original action and attorney discipline, no briefs filed.
May it please the court, Amanda Voth on behalf of the Office of the Disciplinary Administrator, present and ready for argument.
It also may please the court, Michael Stedman. I'm representing Thomas McDowell, the respondent, and we are ready for argument.
Your Honor, that concludes the docket for the week of March 31st through April 2nd.
Thank you, Mr. Shima. I will now call 125925, State of Kansas versus Adam Drew Humphrey.
Good morning, Your Honor. My name is Randall Hodgkinson. I'm appearing today on behalf of Adam Humphrey. I request 3 minutes for rebuttal, please.
3 minutes is granted. Thank you.
Your Honor, I would remind the court, this is a case out of Saline County. Mr. Humphrey pleaded no contest to battery of a law enforcement officer involving great bodily harm to a Salina police officer. Mr. Humphrey received a little over 20 years in prison for that. But the issue before us today is he was also assessed a little over $40,000 in restitution. Again, the question isn't whether Mr. Humphrey is responsible for some amount of restitution. There were there's bodily injury in this case. So the issue isn't whether Mr. Humphrey is required to pay some restitution. The amount of the question is how much in this case. That's the issue that this court granted review on. We claim that in our appeal to the Court of Appeals that the documentary evidence that the state submitted to support the restitution claim in this situation was not substantial and competent evidence to support an award of $40,000 in medical expenses when, for example, some of what was listed in that was legal expenses, and several of the things in that document were things that we don't know what they are. We don't know what they are today. And so our claim was that that's not substantial and competent evidence. The Court of Appeals said I was making an evidentiary claim, somehow maybe that document wasn't admissible, and because we hadn't objected to it below, that we had waived that under 6404. And again, I appreciate the Court of Appeals help in helping me frame my issue, but that was not the issue that I raised. The issue that I raised was whether or not there was substantial and competent evidence, whether that document constitutes substantial and competent evidence to support the restitution award.
And beyond Rule 6404, which seemed to be the rationale of the panel, do you also believe that the preservation rule, our sort of common law prudential document rule, doesn't apply either to a substantial competent evidence challenge because it's akin to sufficiency of the evidence holding the state to its burden of proof? Is that your argument?
That's right, Your Honor. And in fact, I mean, we can look at in contrast. So my colleague cited like State v. Shank for the proposition that if you fail to object to the workability of a restitution plan, that then you can't bring it up on appeal. In fact, by the way, I mean, that's part of why I didn't raise anything about workability in this appeal, because this court has said, if you do make that objection, you, the defendant, have the burden to show it's unworkable. You have to put on evidence, I assume substantial competent evidence, that it's unworkable. And there's no evidence of that in this case. That's why I didn't raise any issue about workability. But I do believe, and I believe this court's precedents in Smith, for example, stand for the proposition that the state does have the burden to show substantial competent evidence to support its restitution award. And so, yes, now my colleague has accused me, or maybe that's too strong a word, but has asserted that I'm conflating sufficiency and substantial competent evidence review. And that's a fair assertion in that, yeah, I agree that substantial competent evidence is like or is akin to sufficiency. It is the job of an appellate court reviewing the record and looking at all the evidence in a light most favorable to the party that prevailed below to see whether or not there is some evidence, substantial competent evidence to support that award. And so, yes, Your Honor, we are, again, it's hard because restitution isn't a civil judgment. This court has said restitution is not punishment. So perhaps it's some sort of sui generis award. It's not entirely clear. But certainly this court in Smith said that every restitution judgment must be supported by substantial competent evidence.
And then on the merits, let me just, if you don't mind talking a little bit about that, your briefing or your petition suggested the only evidence was the exhibit that, or the attachment to the PSI, the chart that you've explained. But in our Taylor decision, we sort of clarified that the responses elicited by a trial court judge at sentencing is also considered evidence, albeit it's unsworn. So maybe it doesn't have the same weight, but it's evidence. So we have the exhibit, but then we have maybe a couple of responses in the record from the prosecutor, sort of confirming that, yes, these are essentially, I think is the quote, medical expenses.
Responses from the defense attorney, Your Honor?
From the prosecutor.
Okay.
Yeah, I'm less concerned about the defendant's response because it was essentially, as I read the record, saying, I don't have a stake in the game. I don't disagree that they're medical, but the proof that they were medical, I mean, there are a couple other statements from the prosecutor that says these are essentially medical expenses. Is that enough to get it over the substantial competent evidence hurdle?
Obviously, we argue that it's not, Your Honor, in that, and particularly when you look at Smith, I mean, the party said, we think the damages are 4,100 in this case, but the court said, look, you still have to look at all the evidence and say, does the evidence support that assertion, even by an attorney in that case? And so when you look at that, at the documentary, this case, the only documentary evidence of what this was, and you look at, and you can say, were all of those medical expenses? One of them was listed as legal expenses. And so this court can say there seems to be a problem with the proof in this case. That's our argument that the Court of Appeals would not hear.
Maybe one last question then. Is there any argument from the record that you could construe the district court judge's ruling to be an award of damages as reflected in the exhibit, and the judge just used medical expenses as shorthand as a descriptor for all those categories of expenses? And even if you could construe her ruling that way, would it even matter if we don't know what those categories are?
It would be, okay, I'm trying to break down your question, Your Honor.
Sorry, 2 parts. I guess my first part of my question
Your
is.
last question. Go ahead, Your Honor.
I was just going to say, the first part of my question was simply, did the district court judge rule that she was awarding restitution limited to medical expenses? Or was it a broader ruling that, no, I'm just awarding restitution as reflected in this document?
Your Honor, so the answer to your first question is I don't remember standing here, like how detailed the district court's ruling was.
Okay.
But the answer to your second question then is it wouldn't matter, because the point is, whatever those things are, they have to be there has to be proximate cause and direct and sufficient but for cause that my client caused them, and it's not something else. And whatever the ruling was, the document in this case we argued is not substantial and competent evidence that it was my client's responsibility. Your Honor, again, but the remedy in this case, if you agree with that, I mean, you could remand this to the Court of Appeals because they never heard this. So this had, the merits of this have never been decided by an appellate court. So that's one possibility. You could reach the merits. And if you do reach the merits, under Smith, you've said in a situation very similar to this, you could remand it for further hearing on what these other things are in this document. That could be an appropriate remedy. Or you could just simply say that the state failed to prove these things and reduce it to what was medical expenses, that there is a clear link in that of a little over $17,000. So we would ask for that in your case, Your Honor. Thank you.
Good morning, Your Honors. May it please the court. Assistant Solicitor General Ryan Ott, appearing on behalf of the state of Kansas. Generally, our courts, when we deal with restitution, our courts require that any argument of restitution on appeal be preserved. As my colleague noted, I cited Schenck in my brief, but also this court's opinions in King and Hunziger required. King had to do with workability, Hunziger with an argument that the restitution wasn't fair market value. Both required preservation. Arnett required preservation, although it decided to go ahead and hear the merits, but it did note preservation was required. And I would note that even the defendant in Smith recognized that he had to raise preservation because his substantial competent evidence argument wasn't objected to below.
But isn't it a different animal, though, substantial competent evidence? I mean, it's really, to me, it is almost akin to a sufficiency challenge. It's just, in this case, it's the judge that's the fact finder, not the jury. And you're testing whether that record held the state, in this instance, to its burden of proof.
I just want to make sure I understand your argument or your question correctly. You're asking me if it's substantial competent evidence is different than the other cases that I mentioned.
Correct. Yes. And why it may not be the type of argument, just like sufficiency of the evidence challenges, that wouldn't really fall under our preservation rule umbrella.
I agree that it is different than workability, and it's different than whether you're liable for the entire amount. But while substantial competent evidence might be similar to sufficiency evidence, I do think there's a difference there, and that sufficiency evidence it really goes to whether I mean, we see it most in criminal convictions, whether a conviction was supported by evidence. When my colleagues, the cases he cited to all were for convictions, whether conviction was supported or not, restitution. Whereas substantial competent evidence, it asks whether the facts support a certain legal conclusion. Here, what's issue is whether this restitution was for medical expenses. The court determined, based on the evidence provided, that it was for medical expenses. And so the question is, does the evidence support that legal conclusion? And whether does the evidence support whether Humphrey's injury was excuse me, whether Humphrey's injury caused Officer Way's injury and the medical expenses. And here the failure to object didn't provide the district court with that opportunity to make those necessary factual findings that could have supported that legal conclusion, that could have allowed this court to make frankly a full determination based on the evidence.
But the court made the factual finding, right, that the 40,000 some odd dollars was medical expense.
Yes, the court did determine that. And that's something that Mr. Humphrey and his attorney both agreed to. Or I should say, rather, his attorney said that he didn't disagree when the court asked Mr. Humphrey directly if he disputed that. He said no as well. And based off of that, as well as the state stating that the document constituted a breakdown of what was essentially medical expenses, the court made that determination.
And so it almost sounds like the argument is that the failure to object sort of didn't give the state or the judge the opportunity or especially the state, to develop the record to support a district court finding that those were medical. But that's sort of, in Smith, we sort of rejected that line of thinking under the invited error doctrine.
I disagree with your interpretation of Smith. At the Supreme Court level, Smith was about the invited error doctrine.
Right.
And as you said, and rejected, saying that acquiescence is not invited error. And we don't argue that invited error occurred here. And then Smith went on to found there wasn't substantial competent evidence. But there is a difference between Smith in this case on that level. And the difference is that in Smith, the evidence was at trial that Smith stole approximately $3,000. And then at the sentencing hearing for restitution, they asked for $4,000. And his attorney said, I agree with that. The evidence was at trial. So it's very clear that there was no evidence to support a $4,000 restitution, which is why this court remanded to give the state an opportunity to actually hold an evidentiary hearing. Here we do have an additional evidence in this document that's included in the PSI, which provides different evidence. But then I would just also state that there's a difference in that. I'm sorry, I lost my train of thought. Smith did not address preservation all in the Court of Appeals. Smith acknowledged he didn't object. He then argued an illegal sentence, and then also raised the preservation exceptions. The Court of Appeals said, even if we assume this is preserved, there's invited errors. So the Court of Appeals did not address it, ruled on invited error, and this court on the petition for review just addressed the invited error issue, not preservation.
So under your position, if in the next case, if we adopt your position in the next case, if the table that we see here only included legal expenses, it was $100,000 in legal expenses, and there was no objection lodged, then we couldn't hear that.
Not necessarily, Your Honor. If there was no objection lodged, it's not preserved, and then it's the appellant's burden to raise the preservation requirement or the exceptions to the preservation requirement, and to argue whether one of those applies. This court, as the Court of Appeals noted, appellate courts have the discretion to decide whether to hear unpreserved claims. So it would be unpreserved. The defendant could argue.
So it's your position that we have discretion to hear it?
Yes, it's my position that you have discretion to hear it. The Court of Appeals determined that it was not going to hear it due to the lack of an objection and the lack of any argument as to the preservation exceptions.
Okay, and if we do go to the substance, would you concede that legal expenses are not medical expenses?
Are you talking about specifically this case or are you
This case,
hypothetical?
this case.
Not
Oh,
necessarily.
I could say, okay, every case. I don't know.
Not necessarily, Your Honor. I admit there's not a lot of detail here. There's not a lot of description, which would have been very helpful.
There's a pretty big description, legal.
But this is, as the state noted when it submitted this document, this is a breakdown of medical costs. And well, I would submit that this is, this resulted from a crime. Officer Way was shot in the line of duty, and the city the city paid for his medical expenses.
What does that have to do with his legal bills?
It doesn't say that it's for legal bills.
It says legal.
It does say legal, Your Honor. I'm not ignoring that. It could be for his legal bills, but frankly, it could also be the legal department had to fill out documents for workers' compensation. That could go to the medical expenses too. We don't know, which is why if this court finds not substantial competent evidence, I've asked you to remand to the district court for a full evidentiary hearing, because it's not a super detailed document. I acknowledge that, but I still would argue that there's substantial competent evidence that a reasonable person could look at this, look at the state's explanation that it is a breakdown of the medical expenses. The breakdown suggests that there would be multiple categories within the medical umbrella, as well as Mr. Humphrey and his attorney's acknowledgement, or at least agreement that they agree that it's medical expenses, and find that supports that, or that the substantial competent evidence that this is medical expenses.
What if, what if it didn't have the table? What if it just said medical expenses and had a number?
I would argue that it says medical expenses, and that would be sufficient evidence, especially considering their acquiescence.
What do you have to prove to show restitution? What does the state have to prove?
We have to prove proximate cause. So we have to show cause and fact and legal causation.
So if medical expenses, if he had medical expenses, well, we could change the plaintiff to a woman, and she had medical expenses associated with the pregnancy that was unrelated. I mean, she had the baby before this incident even occurred, but they were medical expenses. Is there sufficient evidence to show if it just says medical expenses?
No, you have to show that there is a relation between the crime and the restitution of medical expenses, but.
And where was that shown here?
Well, I would note that Humphrey does not dispute that his crime of conviction led to Officer Way's injuries. There's really no dispute that Officer Way is injured.
Where does it show that these medical expenses were associated with his injuries?
Because the document provided by the state is a breakdown of the medical expenses. That's how the state presented it, and that's how, I mean, his attorney and he agreed to that fact.
He didn't agree to it. He just acquiesced.
Okay, he didn't. I apologize. He did not disagree to it, Your Honor. But they had an opportunity there. His attorney did. I mean, object as to workability. Frankly, like I recall, it could have raised workability if he wanted to, because it was preserved. Unlike this argument, but his attorney objected to workability. The district court specifically asked him, "Is that your only argument?" And he said, "Yes, that's all I have." And the district court asked him, "Well, do you disagree with this medical expense?" He said, "I don't disagree." When Mr. Humphrey interjected, he asked, "Do you dispute this?" And Mr. Humphrey said, "No." Yeah, as you said, Your Honor, I fully acknowledge that this is not very detailed. I would love if it didn't just say medical, legal, and it had a huge definition. But it doesn't. This is the evidence we have in the case. And I would argue under the substantial competent evidence standard and proximate cause, it's satisfied here. If there are no further questions, I just ask this court to affirm the Court of Appeals that this issue was not preserved. And if this court were to decide it reaches the substantial competent evidence, then I would ask that it remand to the district court for a full evidentiary hearing. Thank you.
Thank you.
Your Honor, I don't have anything else in response to my colleague's argument.
Any questions?
Thank you, Your Honor.
Thank you. Thank you to both counsel. Court will take this matter under advisement. Thank you. Court will call case number 128447 in the matter of Thomas C. McDowell.
May it please the court, Amanda Voth on behalf of the Office of the Disciplinary Administrator. Madam Chief Justice, I would like to reserve 3 minutes for rebuttal, please.
3 minutes is granted.
Thank you. This is an original action in attorney discipline regarding the respondent Thomas McDowell, who has been licensed to practice law in Kansas since 1982. I will first briefly talk about the procedural history of the case, then the facts, and then the recommended discipline. This case comes before you today following a day-long evidentiary hearing held on September 24, 2024. The parties did enter into written stipulations prior to the hearing, in which Mr. McDowell admitted to the facts alleged in the formal complaint, as well as the 6 rules violations. And those were KRPC 1.1 competence, 1.5 fees, 1.7 conflict, 3.2 expediting litigation, 3.3 candor toward the tribunal, and 8.4 misconduct. There were 2 complainants in this case. One was KL, the client, and one was a Sedgwick County District Court judge. At the hearing, KL testified, as did Mr. McDowell, and at the conclusion of the hearing, the ODA recommended a 2-year suspension with a reinstatement hearing. Mr. McDowell recommended probation. The hearing panel issued its final hearing report, and it also recommended a 2-year suspension followed by a reinstatement hearing. Neither party filed exceptions, so the findings of fact and conclusions of law are deemed admitted. The sole issue today is the appropriate discipline, and the ODA is still recommending the 2-year suspension with a reinstatement hearing. I'll briefly talk about the facts, and then I'll talk more in depth about the recommended discipline. KL's mother hired Mr. McDowell to file a petition for divorce and to update her will in March of 2018. In the April 2018 will, KL's mother named him as her representative and gave him more property than the previous 1982 will did, which had split all of the property equally among the 4 adult children. Mr. McDowell told KL and his mother to safeguard the original will, which they did. KL's mother passed away in June of 2018, and Mr. McDowell filed a petition for probate on behalf of his client, KL. Mr. McDowell did not attach the will, and he did not file the will. According to statute and administrative rule, he has 6 months in which to file the will. KL's sister objected to the petition and noted that no will had been filed. She attached the 1982 will to her objection, and this objection was made within the 6-month limitation. KL also emailed Mr. McDowell and questioned him about the will not being on file. This was also within the 6-month statutory limitation, and Mr. McDowell assured KL that there was no problem with the will. Mr. McDowell also emailed a copy of that will, of the 2018 will, to opposing counsel. Mr. McDowell did not file the will at all within the 6-month limitation. The first hearing was held in January 2020, and the primary issue at that hearing was the admissibility of the 2018 will, since it had been filed about a year late, and it was actually filed by Mr. McDowell's counsel. So at that hearing, Mr. McDowell had hired counsel, and he represented to his counsel, who then represented to the court, that he had hand-delivered the will to the clerk's office. The court stated that it would set a hearing to determine whether the clerk's office had lost the will. However, it was learned that the clerk's office actually never had the will, and Mr. McDowell knew at the time of the hearing that the will had not been taken to the clerk's office. Following the January 2020 hearing, Mr. McDowell called KL in a complete panic and asked him to come into his office for a meeting. At that meeting, Mr. McDowell suggested that opposing counsel had tapped or cloned one of their phones and suggested that they only meet in person to discuss sensitive issues. This is also the first time Mr. McDowell tried to get KL to believe that KL withheld the will, because Mr. McDowell was trying to get the will admitted under the innocent beneficiary exception. However, KL actually never did withhold the will. Mr. McDowell never initially asked KL for the will, and Mr. McDowell actually had a copy of that will. But he was trying to get the will admitted in order to cover up his own mistake of not getting it timely filed. Mr. McDowell's suggested course of action exposed KL to liability under the statute, and Mr. McDowell told KL that it was his fault that the will was not timely filed, but that was not true. In February 2020, Mr. McDowell filed the original will for the first time, and this was over a year after the limitation had passed. He argued the statute of limitations was stayed, and he also alternatively argued that KL had innocently withheld the will, and he mistakenly believed he needed to safeguard the will forever. These were false statements, and this line of argument subjected KL to liability. The district court concluded that KL was not an innocent beneficiary. He could have produced the will at any time, and it excluded the 2018 will. Mr. McDowell filed an appeal, which he later admitted lacked merit. The Court of Appeals noted the conflicting and evolving explanations for failing to admit the will. Around the same time, Mr. McDowell said that he asked for KL to be referred to a malpractice attorney. The malpractice suit was filed, but it was not prosecuted after the attorney found out that Mr. McDowell did not have malpractice insurance. Mr. McDowell had previously told KL that nobody would come after him for malpractice because nobody would get any money since he did not have malpractice insurance. In his formal answer, Mr. McDowell admitted that he committed malpractice, and despite this conflict, Mr. McDowell stayed on the case. Mr. McDowell continued charging legal fees to try to fix his own mistake, amassing $82,000 in legal fees. The court later released his attorney fee lien and sanctioned Mr. McDowell over $60,000 in the form of attorney fees, which went into the estate, or to pay for the attorney fees in the estate case. KL fired Mr. McDowell and proceeded pro se in November of 2021. They reached a settlement in which KL did receive some property, but not as much as he was supposed to under the will. In a filing in September of 2022, so that's about 2.5 years after the initial hearing where it was the issue of the will came up, Mr. McDowell admitted that he was unaware of any legal necessity to file the will, and he acknowledged that attempting to admit it under 59-618 was not a viable argument, but he said that the only willful conduct was KL keeping the will. So again, 2.5 years later, he was still blaming his client for his own mistake. The court issued a ruling on November 10, 2022, and it called Mr. McDowell's actions egregious. It said that Mr. McDowell had greatly increased the time and labor and expense for the case, and that Mr. McDowell knew or should have known his counsel's statements to be false. It stated that many of the actions, including putting KL in legal jeopardy, were either to avoid responsibility for his failure or in a failed attempt to admit the will late. It also found that many, if not most, of all of Mr. McDowell's actions were not done in good faith, and that his conduct was willful and part of a 4-year pattern.
I'm going to jump in right there.
Sure.
And I know you said you would get to the discipline. Maybe I'm hurrying you up. Given all of that, you have a lengthy course of conduct that is clearly intentional and it's devised. It's not spur of the moment. It involves lying to the court, committing fraud on the court, effectively stealing money from the client through fraudulent billing, not to mention just the simple incompetence that started this entire fiasco. Why only 2 years is my question.
So in this case, Mr. McDowell stipulated to the formal, all the allegations in the formal complaint. He stipulated to violating the rules, and he stipulated to the admission of the exhibits, and at least in writing, he admitted to his wrongdoing. He has only one prior disciplinary history, one prior incident. And the other factor is that we are asking for a reinstatement hearing. So all of those taken together is the reason for 2 years, because at the reinstatement hearing,
But do you think that, I guess what I'm asking is this kind of conduct amenable to some kind of rehabilitation? I mean, yes, no prior, arguably no prior discipline mitigating, but these seem like deep and fundamental problems with a person's ability to practice law, and I'm concerned that even after 2 years, and even with a reinstatement hearing, how do we trust that? I mean, to put it bluntly, that the respondent is capable of honestly practicing law.
And that concern makes sense. And so at the reinstatement hearing, which eventually would come at some point, whether it's 2 years, indefinite suspension, disbarment, presumably there would be a reinstatement hearing. And we would be looking for whether he accepted responsibility and could actually articulate what he did incorrectly, what steps he has taken, and how he harmed his client. So we would be looking for what he can show at the reinstatement hearing.
Thank you.
So in closing, I would just note that we are asking for 2 years suspension with a reinstatement hearing. Probation is not appropriate for numerous reasons. One is because there's dishonest conduct. Secondly, the probation plan was not sufficient to protect the public. And then finally, there was no affidavit of compliance filed in accordance with Rule 227F. So because of his failure to file the will, timely dragging out the litigation, and the incorrect information, blaming his client for everything, we are asking for a 2-year suspension with a reinstatement hearing.
And what about any sort of restitution, or where's financially, the injured parties, where do they stand from your perspective today?
Restitution is tricky in this proceeding.
Yeah.
But if you're asking as a whole, the restitution. Yeah.
Not necessarily what we should do, but just what has happened in terms of shaking that all out.
Nothing has happened. There has been no attempt to make any sort of restitution, and the malpractice case was dismissed because he didn't have malpractice insurance.
Right, the court ordered sanctions, right? And so do we know an update on whether any of those sanctions have been submitted to the court, or?
Mr. McDowell did pay the sanctions of $61,000, and that was to pay attorney fees for opposing counsel in the estate case. So none of that went to KL. Thank you.
Thank you.
Morning, and Madam Chief Justice, could I have 3 minutes for rebuttal, please?
We usually don't do rebuttal after the disciplinary administrator's final argument.
Very good.
So
What I was involved in Mr. McDowell's prior discipline, and this was around the same time that some of these actions were taking place. So I was privy not to this case. I knew nothing about it, but I was privy to some things that were going on with Mr. McDowell's office and how some things had radically changed in his life. And I don't think you're seeing, because everything that counsel has told you is in essence correct, because this is a case where he simply didn't submit the will within the 6 months, and he didn't do that because he didn't know he was supposed to. This was the first probate case he had ever filed.
Well, that's not really what this case is about, is it?
No, it isn't.
I mean, if that was the case, we might, You might be up here with an agreed upon probation plan. You might have even had a diversion or, you know, it was, you screwed up on the will. Don't do that again.
Right.
We had a 4-year course of conduct with a lot of bad behavior to cover it up.
Yes, and what Judge Rumsey is our probation, well, not our probation, but our probate judge in Sedgwick County. And Judge Rumsey evidenced in a journal entry, this was what had occurred when attorney fees were ordered. Part of that, that is when Mr. McDowell had asked for his attorney fees to be granted. They were rightfully denied. And the attorney fees that were ordered were paid within a little less than 30 days. This is an instance where Judge Rumsey also had stated that he didn't see a lot of good faith after the initial filing of the case. And there were volumes and volumes of documents filed. So I looked at every one of them. And yes, you are very correct in your point, Justice. I simply note this is not typical behavior of Mr. McDowell. I had Mr. McDowell see a therapist. I had Mr. McDowell do additional education. I've spent a great deal of time with him on this. And this is something that is outside his behavior, but the court did find there was a selfish motive. And we stipulate that is an accurate statement. There were 2 clients, starting with Alma, who did not live very long. There was a divorce he did get granted. Right after that, there was a will prepared. Will was done. She passed away from cancer. She was very, very ill even during the divorce. Then her son, Chris, became the client. When the malpractice occurred, this was back in 2018 with the initial filing and the 6-month going by without attaching the will, filing the will, doing anything with the will other than submitting it to other counsel. That is a terrible problem. There was an appeal filed, and basically it was just over not filing it within time. There were not fees assessed against that, but there certainly were fees assessed against his other behavior. We understand that. We're simply asking the court to consider, we know suspension is necessary in this case. We know that the panel was very thoughtful in what they went over, and they looked at all the mitigating and all of the aggravating circumstances. And a lot of this, I just wish he had reached out to me on this case. He is working now with Steve Johnson in Newton, Kansas. Mr. McDowell quit his practice in Wichita and went to Newton. So he is in Harvey County practicing. Steve Johnson, the attorney, is 78 years old. He's present along with a lot of other attorneys from Sedgwick County that are here to support Mr. McDowell, because Mr. McDowell does possess many wonderful qualities.
Do you guys agree that the client was financially harmed by the malpractice of the respondent?
Absolutely.
Then why aren't you making arrangements to get them paid regardless of whether there's insurance or not, and regardless of whether there's a court order to pay? I mean, you pay $61,000 in sanctions, you said, within 30 days because of a court order, and yet the victim here, nothing's happened from the representation of the other side. That doesn't show contrition, that doesn't show responsibility, that why we should put somebody back out on the street with a license to practice law. From my perspective.
I understand, Justice Biles, and I think your point is well taken, and that is something that must happen. This is something, if he is to return, he needs to make this right to Mr. Leslie. I know Mr. Leslie is present today on this. And so this is something that was very near and dear to him.
Do you know what the claim damages were in the filed malpractice action?
No, that action was dismissed very quickly. And
Is there anything else in the record that would indicate even a rough estimate of the amount of damages suffered by the victim?
that's an excellent question. There was a family settlement agreement that was reached. And in
Well,
that,
that wouldn't, would that show the damages suffered as a result of your client's conduct?
no, there would be nothing that would indicate what that was had he properly.
I mean, the
filed.
closest thing we might have might be and understanding it's just an amount claimed, but the claim damages in the malpractice lawsuit.
Yes, there was an ancillary action filed in Oklahoma, as there were 6 properties and 4 of those were in Oklahoma. Both of the Leslies passed away, Alma and her husband, during this. And so at the very end, there were 2 probates going on for both of them. And then it came down to how much the children would receive. They were all adults. So we are simply, I think Mr. McDowell needs to make restitution, of course. That is a given. But he has taken some measures to make sure something like this would never happen again. And that's why he's associating with Mr. Johnson in Newton, Kansas, who has a long history of doing this type
What kind of
crimes.
measures can a lawyer take to stop himself from committing fraud on the court? I mean, how does that work?
And I know that the court had specifically stated, and this is what Judge Rumsey found, that he wasn't sure because he believed there was a conflict of interest, which we have stipulated to, because there was a conflict of interest and there were damages that occurred as a consequence of that. He wasn't sure if he was advancing the causes of his client, the son, Chris Leslie, or his own for his failure to file the will.
Okay, but my question was in response to your argument that your client has taken steps, preventative steps, to ensure this doesn't happen again. And my question is just, what are those steps when what happened was dishonest conduct with a selfish motive? Like, what are the steps that prevent that from happening again?
I think the steps that would be necessary this is behavior that does not make sense for this particular individual who has enjoyed a good, honest reputation. What we saw here, though, was something different. And I am confused by that. And I am saddened by that.
Well, I'm not hearing you articulate any actual steps.
Right. Well, he has to stop that type of behavior and never let that occur again, would be the action that must occur.
So
And
what do you want? I mean, what's your recommendation for how your client digs out of this hole?
I would like for him to be able to resume practice after a hearing, we understand, and perhaps.
He's got to be suspended for a period of time. What period of time are you suggesting?
I am suggesting 6 months to 1 year. And afterwards a hearing would be necessary. We know we have concerns, and we would like to see what progress is made towards restitution and the words that are being said today about those.
And on the restitution, I think the panel's finding in paragraph 76 suggested that that KL would have received 273,000 to roughly 310,000 had there been a proper administration. Is that at least one part of our calculation in terms of what that restitution might be?
I think that's closer to what it could be.
Okay.
But as far as
Less the whatever 155 that he ended up with.
and he did pay actually, it was just about 61,000. But those were just.
What was the 61 part of the 80,000 that he had billed to the client? And is that where did the 61 number come from? I know that was what the sanction was from the district court.
Right. There were various attorneys for the other side, and they had filed their requests with a petition to be admitted. And the judge took that under advisement after hearing evidence and entered that ruling.
So the sanction actually had nothing to do with the fee rule violation. It wasn't intended to take money away from the respondent that he should not have received.
That is correct. The judge did say that this is not by any means the end of this. This is just what this issue of fees was brought by Mr. McDowell and by the other
Yeah, so the
parties.
61,000 can't really be considered restitution at all. It's entirely separate.
I would agree.
Okay.
Because it's payment of attorney fees. The attorneys did well in this case, but the clients did not. And that is what I think is the essence of this. I simply want the court to consider the mitigating circumstances. We do have someone, and we do have a small county that he is now serving. And I don't believe this type of behavior would ever occur again. This is a kind and considerate man. And the behavior that we saw here was very different than that. I also know he lost his father in 2019, and there were multiple factors that happened with a lot of the people that were around him that he practiced with daily were gone. And some retired and some had to move out of state, but he had a very close-knit family that was removed from him when I was working with him. And we've had a lot of very long conversations about how important it is for us to not be afraid to ask for help and don't let our ego get in the way of what we can do for our clients. And he does have people that can manage his practice. So with all of those reasons, we would ask for the court to do this with great humility, because we know we're walking in here without paying restitution. But part of that is the goal, and to making Chris Leslie right, Your Honor. Thank you.
Thank you. So.
There are just a couple of clarifications, although I think you got there. Just as well, you had mentioned paragraph 76 in the final hearing report, and I would just point out paragraph 78. So on the next page, it said that KL estimated that he received between 118,000 and 155,000 less from his parents' estate because of the respondent's actions. And then the other thing is on Exhibit 39, which is Bates 352. The court does have a breakdown of where that $60,961.80 went. And it did go to 4 different attorneys and then KL's sister, I believe, for being the administrator.
Right, but the sanction wasn't based on the fee violation.
Correct.
So did the victim pay the respondent $80,000 of legal fees?
No.
Did he pay?
That's what I was trying to figure out.
Did he pay the respondent anything, or an initial retainer up front, or anything that he didn't get back?
My understanding is that there was an initial retainer that KL and his mother did pay. But other than the initial retainer, I don't believe there were any attorney fees paid.
Okay, thank you.
Yes. If there are no other questions, then I would waive the remainder of my time.
Thank you. Thank you to both of you for your arguments this morning. Court will take this matter